Good evening, everybody. Welcome to this European Movement webinar about the European Convention on Human Rights. You're very welcome to join us. This has actually been one of our most popular webinars in recent times. Just very briefly, some quick housekeeping messages. First of all, this is being recorded. We will be publishing this on our YouTube channel hopefully tomorrow once it is all completed. So if you're unable to catch it in its entirety, it should be available to watch on YouTube. The format of this evening, we have three excellent speakers who I'll introduce to you in a moment. Each of them will be speaking for roughly about 10 minutes on the main topics that we're discussing. And then after that, we'll go to question and answers from the audience. If you have a question to any of the speakers, you can use the chat function at the bottom of the screen. Just enter your question and we'll be pulling up a selection of them after the three speakers have spoken. So the European Court of Human Rights is obviously the international court that was set up in the aftermath of the Second World War in order to protect people from tyranny, and even to this day it protects our rights to a fair trial, to liberty and security, to freedom from slavery and human trafficking, equality, freedom from discrimination, your right to family life, privacy and property, as well as freedom of speech, freedom from torture and ill treatment. There's been a lot of talk recently about removing the United Kingdom from the European Court of Human Rights. This is obviously something that is incredibly concerning, and our three speakers this evening will talk us through a bit more of the different aspects of that. Just a note to say with great pride that the European movement was heavily involved in the drafting of the European Convention of Human Rights in the late 1940s. So you can, even if you go and visit the Court of Human Rights today, you can see an original copy of the draft that was submitted to the Council of Europe with Winston Churchill's original signature on the front of it. So obviously the European movement is very proud to have been involved from the very beginning, and it is very much something that we continue to campaign on. We have a live petition as well, currently addressed to Rishi Sunak, so we'll see if he remains to be Prime Minister as well. So looking to our three speakers, we are very lucky to have three distinguished speakers this evening, all of whom are experts in their field. We'll start with Andrew Cutting, who is the spokesperson and media officer at the Council of Europe. Using his knowledge, communication skills and professional experience Andrew has developed over the years in his role, he is an invaluable network of contacts, and he can raise awareness and understanding and the appreciation of the Council of Europe's work and the values that underpin it. After Andrew, will be followed by Jessica Seymour KC. She is recognised as one of the country's leading specialists in public and regulatory EU and human rights law. She has also worked at the European Commission's Environment Directorate in Brussels, at the European Court of Human Rights itself in Strasbourg, and the Human Rights Ombudsman Office in Sarajevo. She is the UK's nominee for a judge at the European Court of Human Rights. She's also the chair of the Bar of the European Group and is in the Bar of the Council of the EU Law Committee, and is a visiting professor at LSE and Goldsmith, an incredible CV. And we'll be very pleased to hear from her this evening. And finally, Dominic Grieve KC, barrister and former politician who was Attorney General for England and Wales from 2010 to 2014, as well as obviously being a member of Parliament. He is also Vice President of the European Movement as well, and we're very proud to have him too. So I hope that you will look forward to hearing from our distinguished speakers this evening. Without further ado, I'm going to hand over to Andrew Cutting, who's going to tell us a little bit more about the ECHR itself.
Thank you, Emma, and thank you very much for inviting me to speak at this very interesting webinar this evening with such an amazing panel of distinguished speakers. My name is Andrew Cutting. I'm a spokesperson for the Council of Europe, which is, of course, home to both the European Convention on Human Rights and the European Court of Human Rights. It's based in Strasbourg. And my role is, I'm part of the central communications team at the Council. So I work on media relations regarding the UK, but I also cover, for example, relations with the EU and the ECHR system, among many other things. So I would like to speak to you a little bit about the history of the Council of Europe and the ECHR system, about how the system works, about the UK's role in Strasbourg and impact on the system, and vice versa, the system's impact in the UK. And then possibly, if there's time, talk to you a little bit about some of the misconceptions there are about the Convention and the Court, some of which you may be familiar with. So we'll start with some of the history. So as you rightly mentioned, the Council of Europe was one of a number of different international organizations created shortly after the Second World War, with the aim of helping to maintain prosperity and stability and security in Europe. It was largely inspired by Winston Churchill, and it was actually born on the 5th of May, 1949, with the Treaty of London. So we're celebrating our 75th anniversary this year, as well as the European movement. And the organization was initially considered as a kind of soft security counterpart to NATO, if you like, which was created at the same time. A few years later, along came what is now the EU, and kind of overshadowed the Council of Europe to a certain extent, but the Council of Europe carried on working in the background and expanded quite rapidly, certainly after the fall of the Berlin Wall at the end of the 1980s, early 1990s. And we welcomed in many new member states from Central and Eastern Europe, many of whom were on their road to eventually joining the EU. So up until a couple of years ago, the Council of Europe covered pretty much the whole of Europe. We had 47 member states before Russia was excluded in 2022, shortly after the invasion of Ukraine. So we now have 46 member states, so pretty much every country in Europe, apart from Russia, Belarus, and Kosovo, which has recently applied to join. So the UK is, of course, a member, and we have many countries like Norway and Switzerland and Turkey, which are not members of the European Union, but are members of the Council of Europe. And what we do is we set binding international standards in many different areas, focused on the principles of human rights, democracy, and the rule of law. And these, so we have drawn up more than 200 different international treaties, which we call conventions, on issues ranging from torture to violence against women to the most recent one is on artificial intelligence. But very much the basis of what we do is the European Convention on Human Rights, and that pretty much runs through all different aspects of our work. The Convention was the first international treaty that was drawn up by the Council of Europe. It itself was based on and inspired by the UN Universal Declaration on Human Rights. And it was largely drafted by British lawyers, notably David Maxwell Fyfe, who many of you watching this evening may be familiar with. The United Kingdom was the first country to ratify the ECHR, and the convention entered into force in September 1953, so 70 plus years ago. The system has evolved over time, and the convention is now backed up by this independent international court in Strasbourg, which is, of course, the European Court of Human Rights, which issues legally binding rulings. And over the last 70 years or so, well, no, since the late 1950s, in fact, the court has dealt with over 1 million applications and has issued something like 27,000 judgments. So how does the system work? Well, essentially what's unique about the system is that anybody can bring a case to Strasbourg, whether it's an individual or a group of individuals, an NGO, for example. And even a member state can bring a case against another member state if they think that the defendant country has violated one of the rights that are set out in the Human Rights Convention. There are certain criteria. So before anybody takes a case to Strasbourg, they have to go the whole way through their domestic legal system. And there are certain time limits involved as well. So I think it's now 4 months after the final decision at national level, you have to lodge a complaint to Strasbourg within that 4 months, or else the court won't consider your complaint. And your complaint, of course, has to be relevant to one or more of the rights which are set out in the European Convention on Human Rights. So if a case makes it through all of those different stages and is not immediately rejected as being inadmissible by the court in Strasbourg, then the court comes up with judgments which are legally binding on Council of Europe member states. And there's a whole system in place as well to make sure that these judgments are actually put into practice. So they're not just, you know, these lofty declarations or words on a piece of paper. We have a body called the Committee of Ministers at the Council of Europe, which is made up of representatives of the member governments, so national representatives. And they keep an eye on each case to make sure that progress is made towards implementing the judgment. And that can mean paying damages to the victims of human rights violations. It can mean, for example, taking measures to improve their situation by releasing somebody from prison, for example, or from having a retrial if there's been an unfair trial. And it can also mean putting pressure on governments to change their legislation, sometimes even their constitution, or their policies or their practices, to make sure that the same human rights violations don't happen again. And the Committee of Ministers keeps an eye on every single case through the system of kind of mutual peer pressure, if you like, to make sure that steps are taken in the right direction until the committee is satisfied that everything that can be done to address the problem has been done and the case is closed. So if we look at the UK's record in Strasbourg, we find that the UK has consistently the lowest number of applications per capita of any of our member states. So last year in 2023, the court received around 3 UK applications for every 1 million inhabitants, which is really much lower than some of our members. The court issues relatively few UK judgments, and there are even fewer violations of the convention found by the court. So again, looking at last year's figures, just to give you an idea, the court decided on something like 38,000 applications in total, and that's for all 46 of our member states, 40, well, plus Russia, because it's still considering Russian cases, even though Russia's not a member. So of those 38,000 applications, there were just 176 which related to the UK. There were 3 judgments from the court in UK cases, only one of which found a violation of the Human Rights Convention. 38,000 applications in total, 1 UK violation. So the UK really does make up a very small proportion of the court's overall workload. There were also some 63 requests for interim measures concerning the UK received last year. You may have heard of interim measures recently. They've been in the news quite a lot. And this is when an applicant can ask the court to say to a member state, please either do this thing or don't do this thing if somebody's human rights are at risk. So there were 63 such requests concerning the UK last year, and the court granted 1, which concerned a deportation case actually to the US. So alongside that very low number of applications, low number of judgments, and low number of violations related to the UK also has a generally very good record on implementing the court's judgments. So since the system started, there have been around 500 rulings concerning the UK, which have been transmitted to the Council of Europe to oversee their implementation. And 491 of those have been closed. So we're talking about 98, 99%. And this has included some really controversial issues, if you like, such as prisoner voting, the Abu Qatada issue, you might remember from a few years ago, whole life prison sentences and others. So these have all been resolved within the system, essentially. There's one exception to this generally very good record on implementing judgments, and this is a group of cases relating to Northern Ireland and the troubles in Northern Ireland. The court found violations in a number of cases, alleging collusion between the UK security forces and loyalist paramilitaries in Northern Ireland. And these cases have actually been pending before the committee ministers for over 20 years now, and that is still going on, that is still being considered by our committee ministers in Strasbourg. So very quickly, what impact has all this had? Well, cases that have gone the whole way through the system and been decided ultimately in Strasbourg have brought about a number of important changes within the UK and have changed people's lives in a number of ways. So, for example, we have the ban on corporal punishment in schools that resulted from a Strasbourg judgment. The UK's ban on LGBT people serving in the armed forces, that was lifted after a Strasbourg judgment. More recently, domestic violence victims in the UK have been made exempt from the bedroom tax when they've had a safe house installed in their room. Again, that followed on from a judgment from Strasbourg. We have numerous such examples. In fact, so many, we've set up a dedicated website which sets out around 200 plus case studies of not just UK cases, but cases in all of our member states, which kind of talks you through the story of what happened to the applicants, why they brought the case to Strasbourg, and then what changes were brought about as a result. But then we have to bear in mind that a number of important cases have also been decided within the UK based on the Human Rights Convention. Hillsborough is one issue that springs to mind, but there are many other such cases that have never actually reached Strasbourg, but have been resolved by domestic UK courts. And this is true not just of the UK, but in all of our member states. We've seen really significant positive steps forward in terms of human rights and democracy that have resulted from judgments from the Strasbourg court, as I say, often resulting in changes to constitutions, laws, policies, practices, payment of compensation, and so on. Very quickly onto some of the misconceptions, but we can always come back to this in the questions and answers maybe. Well, firstly, the Council of Europe is not part of the European Union. We've often been confused with the EU and the institution. We even sound a bit like an EU institution, but we are very separate organizations. As I said, the Council of Europe has 46 member states, and we're kind of a broader and looser organization with a lot less money and a very different mandate to the EU. It's not helped by the fact that we both share the European flag that you can see behind me. The yellow stars on the blue background was initially developed by the Council of Europe, in fact, and then shared with the European Union in the 1980s. And of course, they took it and ran with it. And now everybody tends to associate that flag with the EU, whereas actually it's a flag for the whole continent. We also have various allegations thrown at the court as being, a foreign court that imposes unpopular rules on the UK, whereas as I've explained, it was largely a UK creation. The UK remains extremely influential in Strasbourg to this day, is one of the most influential member states, if not the most, to be honest. And there are a large number of British staff in Strasbourg as well. We have we make up the second largest contingent of staff at the Council of Europe and the court of all 46 countries. In fact, it's only France, which is the host country and therefore has a lot of locally recruited staff, which sends more people to work at the Council of Europe and the ECHR. So it's not as foreign an organization as it might seem. I have a couple of other points written down, but perhaps we can come back to those in the Q&A. Very quickly, I'd like to finish just with a quick quote from the President of the European Court of Human Rights, which is currently the Irish judge, Siofra O'Leary. And she put out a statement on our 75th anniversary 2 or 3 weeks ago. And I'll just paraphrase very quickly a couple of lines from that statement. She said, "One of the principal means for achieving greater unity and safeguarding our common heritage was and is the European Convention on Human Rights. The court's judgments have contributed to improving the democratic and social fabric of our societies, making them more inclusive, tolerant, and genuinely democratic. At this critical point in history, when states are confronted by conflict, democratic erosion, and unprecedented challenges, let us also not lose sight of our profound responsibility to pass on to future generations both the Council of Europe's values, human rights, democracy, and the rule of law, and the unique international protection mechanism, which is the European Convention on Human Rights."
Thank you very much, Andrew. Very enlightening, and I'm sure there'll be plenty of questions in the Q&A session a little bit later. Thank you very much for your insights. So next we'll be going to Jessica Seymour, and she will be giving us her perspective on what is at stake if the UK were to leave the ECHR. So handing over to Jessica.
Thank you, Emma, and thank you, Andrew, and thank you to the European Movement for inviting me. So yes, I'm going to deal with the consequences, and I'm going to start with the two main reasons that are given usually by those who advocate Britain departing from the convention, and then give you 6 reasons why it would be a very, very bad idea. And in response to the question that is the title of this event, the fight for the ECHR, what is at stake? My honest answer is everything is at stake, particularly at this rather difficult and delicate time strategically and politically across Europe. So the 2 reasons that advocates for departure give. The first reason tends to be focused around what leaving the ECHR would allow politicians to do. And that is all generally focused around the ability to expel asylum seekers in circumstances where the ECHR does not let them do that. The reality of that is that, in fact, it is not simply the Convention on Human Rights that prohibits states from expelling asylum seekers. It is also the Refugee Convention and customary international law and the ICCPR, the International Convention on Civil and Political Rights. And the reality is that, for example, the Rwanda judgment that the Supreme Court gave recently, that judgment would essentially have been the same even had we not been a member of the court. And so that is a false promise, if you like, I would say, as a matter of international law. It's a false promise to say that Britain can expel asylum seekers to places where they're at risk of torture and death. But then there is also the small matter of morals and ethics. And the UK being unable to do something that violates fundamental rights, particularly the right not to be tortured or killed, is not really anything that one would want to crow about. So that reason seems to me to be a very poor reason. The second reason that tends to be given, and this is in a more sort of academic, intellectual kind of sovereignty world, is its claim that the Strasbourg court has overstepped its remit. It's extended its jurisdiction into areas where it shouldn't be acting. Now, I respond to that, well, how in fact has it done that in a way that is in any sense to the UK's detriment? And my answer to that is it simply hasn't. We, of course, did have the famous prisoners voting case, but that's a fairly small issue. But more recently, we had the Swiss women's case. I don't know if you heard about it in relation to climate change. I acted for the Swiss women in that case. There were 2,038 women older than 65 who brought a claim against Switzerland to say that the failure of Switzerland to enact legislation and take measures to reduce the emissions from Switzerland in line with their international obligations under the Paris Agreement was a breach of their right to life and right to well-being under Article 8. And the court didn't decide the right to life point, but it did decide that the failure of Switzerland to act to reduce its emissions was a violation of those individuals or the association, the individuals who are a member of the association, their right to well-being. And David Cameron in the House of Lords responded that this was outrageous and involved the court overstepping its jurisdiction. But the irony of that is that, in fact, the United Kingdom is taking and has taken measures to comply with its international obligations under the Paris Agreement by way of the Climate Change Act. And Switzerland is effectively free riding. So it's actually in all the states' interests that they should all be held to account. And it is certainly in the United Kingdom's interest that Switzerland should be made to do its bit, because as we all know, there is no way that global emissions can be reduced sufficiently to avoid the 1.5 or 2 degree temperature increase unless all states act. So that judgment, despite what is being said politically, is in fact very much to the United Kingdom's benefit. So then just turning to the consequences, and I've got 6 broad heads of consequence. First, the government would be able, through legislation, to negate fundamental rights of those within the United Kingdom. Now, these are rights that are widely recognized in civilized countries, and they are rights that it is felt post the Second World War, individuals should be able to go to an international forum to ensure that their state is not removing those rights. And it seems to me that there can be no doubt that if we left the ECHR, certain rights would be removed. For example, the Strasbourg Court has found that there is a positive obligation to investigate deaths in custody in an independent way, and that did not exist before it was argued pursuant to the convention. It seems to me that those kind of positive obligations on local authorities, state authorities, to actually do things to protect individual rights would be likely to go. The second head is the undermining of the Good Friday Agreement. The ECHR is a fundamental part of the Good Friday Agreement, and it's difficult to argue that withdrawal of the UK would not breach the agreement. And that would obviously risk intercommunal relations. It would likely significantly harm strategic relations with the United States. And it would also damage relations with Ireland and the European Union member states. The third head of consequence is that it would put the United Kingdom in breach of the Trade and Cooperation Agreement, which would have very significant effects. The central part, there's Article 254 of the TCA, provides that we should comply with those rights. And then if we don't comply with those rights, there can be automatic removal or expulsion of the UK in relation to that agreement in respect of criminal justice matters, enforcement and judicial cooperation. So that would have very significant effects, but it might well also lead to the rest of the TCA falling, albeit with some kind of notice period. And it would obviously plainly further undermine trust between the EU member states and the United Kingdom. The fourth head, undermining the UK's standing in the world as a country that stands up for values, rights. It seems to me that this is absolutely fundamental. This is not a techie legal question. This is a question of good faith, of trust, of a country being seen as reliable as an ally, reliable for investment, reliable for the rule of law. I wouldn't go so far as to use the word rogue state, but it does seem to me that France, Germany, Italy, those large countries would look askance if the UK left the ECHR. And the only country that has ever left the ECHR was Greece when it left in 1970 on the point of being expelled. And it returned in 1974 when it became democratic. And the only countries that are not in the ECHR, there was Russia was expelled recently when it invaded Ukraine in 2022. And then there is Belarus, which is plainly nowhere close to a democracy. So we would be really undermining our relationship with our allies. And I think it would be strategically incredibly dangerous, particularly as it might actually encourage other states to do that. And we really do not want the Council of Europe breaking up. So the fifth head effectively follows from that. It undermines our own strategic interests. It runs counter to our strategic priorities. We need strong alliances, in my view, particularly in the context of Russia and China and Ukraine. We need more multilateralism and not less. And we need to improve our relationships with our neighbours, not undermine them. And the sixth and final reason I give is that it would remove our influence and ability, the influence that was mentioned, the influence we have in the court. Because after all, one of the great things about the Council of Europe and the court is that judges from each member state sit together and share their legal views and of the often moral and ethical issues that arise in the context of human rights arguments. And the view of the United Kingdom judge and the United Kingdom staff, as Andrew has said, is extremely important. We have influence in relation to what is going on in other countries. And the idea that the United Kingdom would help crumble the ECHR and break up those important multilateral relationships seems to me to be a complete madness.
Brilliant. Thank you very much, Jessica. Really interesting insights as well from you. I'm sure there'll be questions in a moment. So finally, we turn to Dominic Grieve. And Dominic is going to talk to us a bit briefly about some examples of the important moments in recent history where the ECHR has protected our rights as citizens. So over to you, Dominic.
Thank you. Thank you very much, Emma. And it's a great pleasure to be participating in this seminar with Andrew and with Jessica. And I will try to be quite brief so that we can have a discussion around the topic. And some of the things I might have wanted to say have, I think, already been covered. I think it's important, first of all, to understand how the convention has evolved. The original idea was that this was an interstate mechanism. So if a country behaved badly, another country could come along and take it to the European Court of Human Rights and complain about its human rights conduct. But from the 1960s onwards, 1966, has been the right of personal petition. And actually, the United Kingdom supported the right of personal petition. And it's that which has made the most profound difference to the way in which the convention works. The convention is a living instrument. It's not fixed in the moral code of 1950. It is allowed to evolve and the judges to look at where societal standards are. And so, in fact, it's proved to be an immensely powerful instrument for bringing about positive change. Now, occasionally, as the change has come about, some people have complained about it. But does anybody really seriously think, for example, that illegitimate children should be subject to legal discrimination, which was the position in a number of European countries until it was stopped as late as 1979 in a case concerning Belgium? Or that interrogation techniques which amount to torture, and which I'm afraid the United Kingdom practiced in Ireland, Northern Ireland, in the early 70s, brought to an end by a judgment of the Court of Human Rights because it amounted to cruel behaviour. And there are, admittedly, the UK has not very often been the subject of adverse judgments, but there are key examples where it has brought about positive change. And even without the judgments, it's noteworthy that when we finally incorporated the convention through the Human Rights Act, it led to government departments spending 2 years before the Human Rights Act came into operation, looking at their practices and saying, well, do we actually meet and comply with the European Convention on Human Rights standards? And just to take one example, which slipped through, it was a judgment through the Human Rights Act, which finally ruled that it was wrong to place elderly couples in separate care homes. something which one might have thought was obvious, but they had a right to a private and family life, and that was being violated by a local authority. But the reality is that, in fact, most of the positives haven't concerned us directly in the UK. They have concerned our European neighbourhood, which was exactly why we signed up to it and why we promoted the convention, because we wanted other countries to enjoy the sorts of rights and liberties that we perhaps took for granted. It may have come as a bit of a shock to realise that sometimes we didn't meet that standard, but on the whole, we have. And nowhere is this more so than with the former countries which were subject to tyranny and of the old Soviet Union when they started to emerge as democratic states. I mean, I could run through an almost endless list of examples of interventions by the Court of Human Rights which have said that practices, standards in psychiatric hospitals in Romania, for example, where people were actually dying in unheated wards, were unacceptable and brought about change. So the positives of our supporting the convention are simply enormous. It is probably the best example of UK soft power since the Second World War. Now, there have been problems. I think that one of the issues has been that precisely because of the challenge posed by the former Eastern European countries that came into the Council of Europe, the court started firstly being overwhelmed by cases, and secondly, probably started a degree of micromanagement which wasn't originally envisaged when the convention was drawn up. So, for example, I've always taken the view that I think the court's decision on prisoner voting, although one can make a very good case for supporting all prisoners having the vote or some prisoners having the vote, was probably a mistake. But it's noteworthy that it eventually got resolved very, very simply and in a way which hardly anybody in the UK noticed. And it's also the case, and I think this is even more important, that since 2012, the court has actually adopted a significantly different approach to its caseload and how it manages its work. And that was the result of the Brighton Declaration that was negotiated by Ken Clarke and myself, which tried to go round all the member states and negotiate a new way in which the court could approach its work. And it appears to have been extraordinarily successful. So we have the ultimate irony at the moment that we have a government that is still chuntering away angrily in the background, insisting that the convention is unacceptable, and now turning from the Human Rights Act to actually saying that we should threaten to pull out of the convention. When in fact, as was pointed out by Andrew, the convention is working very well indeed, and the United Kingdom is hardly ever subject to adverse judgments because we're complying with the convention and doing it very successfully month in and month out. And the cases which do emerge are ones which I would describe as often slightly complex, but they're not insurmountable. So for all those reasons, the convention, to my mind, has been an immense success. And the interesting thing is that the obsession of some politicians with it doesn't seem to be matched by the public. The public may occasionally get a little bit worked up about an individual decision, but broadly speaking, they are supportive of human rights and supportive of what human rights are delivering, both for people in this country, but also elsewhere. So I'm a great supporter of the convention, just as I'm a great supporter of the Council of Europe. And the good news, as far as I'm concerned, is that we have had 15 years of persistent criticism of the convention from my former party, and also actually from time to time from people in other political parties. But actually, the reality is that 15 years down the track, we are still in the convention, we still have the Human Rights Act, and it is still doing good on a day-to-day basis. And we all benefit from it. And the dialogue that exists between the Strasbourg court and our own national courts is vigorous, lively, and not just one way. Just to give one example, back in the early 2000s, there was a case about hearsay evidence in English courts, and the court in Strasbourg had misunderstood essentially what our rules were. And following an adverse decision in Strasbourg, there was then a decision of our own Court of Appeal and Supreme Court, and the case went back to Strasbourg, and Strasbourg accepted the United Kingdom's opinion on it. So in fact, it's a positive dialogue that works at different levels. And the evidence, to my mind, is overwhelming that the convention is doing us a lot of good. Thank you.
Brilliant. Thank you so much, Dominic. So we'll go next to a Q&A. Just a reminder, if you have a question for any of our speakers, please, you can use the chat option, which is at the bottom of your screen. If you can put a letter Q or the word question at the beginning of your comments, then that would be really helpful for us to find it in the rest of the chat. So, Scott, I think we have a few questions already. Would you mind going for the first one? So, first question from Mac User 2006-06. How do we counter the concept that the European Court of Human Rights is a, quote, foreign court?
Well, I might go for it's an international court. I don't understand this sovereignty business. Just so people should understand, the United Kingdom is currently signed up to 14,000 approximately treaties which bind us in different ways and which we have voluntarily signed up to for the sake of trying to improve relations between states, reduce the risk of armed conflict, and facilitate the dispute resolution. And about 800, 900 of them have got arbitration mechanisms for resolving differences of interpretation. And actually, all the European Court of Human Rights is an arbitration tribunal set up by international treaty to be the final resolver of an interpretation of what the convention means. And there are lots and lots of other examples. So it's not a foreign court. It is a court that we have set up with other international actors because we believe that by acting together, we can deliver something which is better. And as it happens, it's not like the European Court of Justice, which did have the power to override our own domestic laws. That was the Court of the European Union. The European Court of Human Rights is an advisory tribunal. Now, of course, if it finds against the UK has to make a decision as to whether it honours its international obligations or not. But it doesn't impose a solution on the United Kingdom and never has. The reality is, on each occasion we have had an adverse judgment, we have thought it in our interests to find a way of trying to meet a problem that the international judgment against us has identified. That's sometimes been done by quickly changing our own laws, sometimes by changing administrative practices, and occasionally by a slightly continuing dialogue, which has eventually led to a somewhat different outcome. But it's all part of a process by which countries come together which share the same values in order to ensure that those values are translated into rights for their citizens. It's not a foreign imposition on us at all.
Great, thanks, Dominic. And I think this is possibly linked to something Andrew said. This argument of it being foreign court sort of deletes the influence that the UK itself has on the ECHR and the amount of sort of number of people that are involved in it, and still even now the influence of the UK is still felt. Would that be right to say, Andrew?
Yes, when I'm walking the corridors of the Council of Europe and the European Court of Human Rights, it doesn't necessarily feel like a foreign entity. There's a lot of British accents around and British staff in key positions throughout the organisation, and the British voice around the table at the Committee of Ministers is a very influential one, it has to be said. And that's been the case. I've been there for 20 years, as long as I can remember. So yes, it's, we're an international organisation.
Absolutely. Brilliant. Thanks. Jessica, do you have anything to add on the point?
Not really. I mean, I suppose one could ask oneself why the word foreign itself sends shivers down people's spines, because really, I mean, one could say, well, yes, there are lots of people who are not British there. There's also a Brit. And we all have different points of view, and everyone shares them and exchanges them, different knowledge, different experience. And that comes through into some kind of ruling, and actually that's beneficial, but maybe one that's not arguable. But seems to me that maybe we should shy away from thinking that foreign is necessarily problematic.
Absolutely. Thank you very much. Can we have the next question, please? So this from a People's Vote Whitney. Are there so few applications related to the UK because of our citizens are unaware of their right to apply to the ECHR, or is it a lack of understanding of its function?
Well, I might just jump in there.
Go on.
I think the bottom line is, to go to Strasbourg, you've got to have gone through your domestic courts. Now, there are two issues. One, it's pretty difficult to go to court in England or in the UK. And when you've got a problem, you don't necessarily go to court. The second thing is, if you actually do manage to go to court, you're likely to get your problem sorted out under the convention, because we have the Human Rights Act. And therefore, you don't have a case in Strasbourg. So I think fundamentally the real reason there are very few cases is because we have a pretty good legal system and we have the Human Rights Act.
So we've got that level of protection already in our own system, and there's actually very little reason to sort of go to the international.
Yeah, well, you can't go there directly. Obviously, you've got to first make your claim in the domestic courts.
Yeah, great. Thanks, Jessica.
One of the nightmares which led, at the time of the Brighton Declaration in 2012, was that some countries had not incorporated, or if they had incorporated, getting access through their own courts was very difficult. So I remember being taken into the basement of the Court of Human Rights and being shown these cards written by people from prison cells in Russia, and Ukraine was another country, but also in Eastern Europe, which were raising issues which ought to have been dealt with at a domestic level, but were not at that time being dealt with in that fashion, and clogging up the court in Strasbourg and making its life really difficult. And we haven't done that. And so when past governments have suggested, oh, well, we might stay in the ECHR, but we're going to repeal the Human Rights Act, my eyes pop out of my head, because the likely consequence is that there are going to be hundreds of UK applications to the Strasbourg court, which serves no useful purpose for anyone. But fortunately, that hasn't happened. And it's the fact, I think, my take as a former politician, or still a bit politician, is that the Brighton Declaration really has worked, I think, very well. And it has reduced the court's workload. But above all, in the UK context, the sort of comity of understanding between our own courts and Strasbourg is now so good that we're not getting cases where our own court judgment is being overturned in Strasbourg. Exactly. It's very, very rare. So actually, it shows the system working in exactly the way that we would want it to work.
Great. Thanks, Dominic. Andrew, anything to add on the sort of how few applications there are from the UK?
No, I would agree with both of the other speakers. I think there's a feeling that the UK system works very well, and that, generally speaking, the UK does a very good job on human rights, and also the fact that when there is an adverse judgment and steps are taken relatively quickly to put it right, as Dominic said, that decreases the scope for these sometimes thousands and thousands of repetitive applications come in and clog up the system from other countries, and we see much less of that with regard to the UK. And I would also stress the whole thing about judicial dialogue between Strasbourg and the UK. It is a bi-directional thing. And I know that, so I've heard, I'm not a lawyer, but as far as I understand, the influence from what happens and what is decided in London, that helps to shape decisions that are taken in Strasbourg as well. It's not just, it is a two-way thing.
Great. Thank you very much, Andrew. Shall we move on to our next question? From Joe Pye. In the event of a government attempting to or even achieving withdrawal, could we as citizens take our government to the ECHR as a breach of our human rights, or is that too simplistic? Joe assumes that we would win if that were the case. Andrew, you're front and centre. Would you like to tackle that one first or pass it on to another?
That's a very difficult question. I'm not quite sure how to answer it. I mean, in practical terms, it's relatively simple to withdraw from the convention. You just need to give 6 months' notice and you're out. I mean, it's much easier than leaving the European Union, for example. Mm-hmm. But whether citizens would be able to take government to the court as I really don't know. Maybe I'll pass that one over to the
I think the answer is no, I'm afraid.
I think the answer is no. I mean, once you're out, then there's no there's no right to take the claim. So if a government wants to take us out and give 6 months notice and we're gone, it's the government's right to do it as an international treaty. A royal prerogative can do it. I would presumably, I don't know what it will do with the Human Rights Act, because that would still continue to apply the convention at a domestic level. If you really wanted to do the whole thing, you'd repeal the HRA and you'd also take us out of the ECHR, at which point we would be living in a country with no protected rights at all, except those which the common law can confer, but they are very limited in reality, although the common law can be quite a flexible tool as well.
Doesn't sound like a very great option in my particular point of view. Jessica, any further to add on what's
No, I don't think so. I mean, there has been some articles written saying that to leave the ECHR, the government would have to ask Parliament, but I'm not even sure that that's the case. I actually think that it wouldn't have to. It would simply have to just write a letter and withdraw, because it is just an international treaty. It's not the equivalent of the European Union.
Okay, good. Thank you very much. Next question, Scott, if we can. So from Mark Walker, if the UK were to leave the ECHR, how would it go about rejoining at a later date? Would it be straightforward? So if you've written a letter and you've given 6 months notice, is it as straightforward to get back in the club if that's what you so decide?
It's much easier than rejoining the EU, I think. Clearly, you would have to make an application, and the application would, I think, be considered both by the Council of Ministers and it would also be considered by the Assembly. But the reality is that no country that wants to adhere to the convention, bear in mind that we'd also probably be leaving the Council of Europe. Because I can't see how you can be a member of the Council of Europe as well if you're not adherent to the convention. The two now go absolutely hand in hand. So I don't think there will be a problem, because if we went along and said, look, we've made a terrible mistake and we've got a change of government and we now want to rejoin and come back into the Council of Europe, I've never heard of the Council of Europe refusing to allow a member state to join as long as it meets basic democratic standards. I think probably be the one criteria. If it didn't meet those standards at all, then joining the ECHR would be a bit odd, and joining the council would be odd.
We'd have to have slipped pretty far.
Yes, I think we'd be in a very bad place.
Very far.
Someone earlier talked about Greece having left and rejoining. My knowledge of Greek history is very poor, so was that about a sort of...
Well, they had a military coup. And the coup overthrew the democratic government. And then they jumped before they were pushed, because they were also violating human rights serially. And then there was the military regime collapsed after the Cyprus crisis. And democracy was restored, and they came back into the Council of Europe very quickly.
Good. All right. So it is less of an insurmountable issue as...
So if Rishi Sunak sends the letter tomorrow, then maybe on the 5th of July we'll just have another letter.
Yeah, can we just
the 6 month period?
Great, thank you. Shall we move on to the next question? from Barbara Callender. Does this have to be passed in Parliament, i.e. leaving ECHR? I think, Jessica, you may have just said that you didn't.
Yeah, Dominic may have another view on that.
No, I think that I don't see that we have incorporated, I know the Human Rights Act is incorporated, but I don't think so. I think leaving the ECHR 6 months notice, I think it could be done by a decision of the cabinet and a letter from a minister. And I don't think there would be anything more that needed to be done in Parliament at all.
I agree.
Obviously, Parliament would have to, in a sense, to approve it. Because if Parliament disapproved, it could bring the government down. But on the basis that the government has a working parliamentary majority that is prepared to acquiesce in what the government's doing, that's it.
Okay, that's pretty clear, I should say. Last question, because we are sort of coming close to time, is always a great one to finish up. Steve Evans asks, what practical actions can we take to either enhance or challenge adverse comments made about the ECHR?
Maybe I could just say a couple of things
Go on, Andrew.
Because I work in communication, so I'm probably more exposed to media coverage of the ECHR than maybe anybody else in the world when it comes to the UK media, and it is a little bit skewed because people only tend to hear about firstly UK cases, which are a very small proportion of the overall number of cases. Secondly, the cases that the UK loses, which is a very small proportion of that very small proportion. And then they tend to mainly hear about cases that are brought by relatively unpopular people or groups, such as prisoners. So most of the media coverage you get about the ECHR system, certainly in the UK, possibly in other countries too, is really quite distorted when you look at the overall workload of the court and the number of issues and countries that it deals with. So how can you counter that? Well, as I said, we have put together this special website on, it's an easy URL, coe.int/ECHR, which gives, I think it's about 200, there it is on the screen.
There it is on the ticket. Yeah.
Positive examples of, genuine important steps forward that have been taken in all of our member states and including in the UK. And if you just have, read 4 or 5 of those about the UK, those are pretty strong arguments to people who think the system is all about protecting prisoners or whoever it may be. It's not. It's there to protect everybody, all of us, and essentially to limit states' capacity to violate the human rights of ordinary people. And those are relatively strong arguments, I think.
Well, yes, you would hope so. But great. Thank you, Andrew. Dominic or Jessica, any comments?
Just going to say, part of the problem is that actually some of the coverage in this country is just woefully inaccurate. I remember taking Rebecca Brooks to task. It's probably a very foolish thing to do at a dinner in 2008. And I pointed out to her that the Sun had on 2 occasions claimed that the convention allowed prisoners to have hardcore pornography in their cells, when it just wasn't the case. It is true that a person had brought such a claim to have hardcore pornography in their cell and had been dismissed at first instance on the first application in the High Court. And that was the end of it. And yet on 2 occasions they made this claim. And it didn't go down very well when I pointed this out to her. So one really has to face up to the fact that people are prepared to peddle complete and total nonsense. Mm-hmm. And I think it is incumbent on us to call it out when it appears. But it can be quite difficult because there are rumors go around which are just frankly inaccurate. And it's very irritating. And I agree so much with Andrew that the reality is that on a day-to-day, people realize the sheer extent to which it's made people's lives better, particularly in some countries which previously they were subject to tyranny. They would realize what an extraordinarily beneficial instrument it's been.
Thank you. Jessica, any other?
I don't have anything to add to that. I think it's incredibly difficult. I mean, the lies and deceit are very, very hard to deal with. I think, you know, as Dominic says, calling them out, you know, don't believe everything you read.
Mm-hmm.
And actually, just literally the words of the convention are pretty persuasive. I mean, you know, a page with the convention rights written down, very few people would disagree with them.
Yeah, absolutely. Brilliant. Well, I think as we've just gone past 7:30, I'm going to say a huge thank you to our speakers, Andrew Cutting, Jessica Seymour and Dominic Grieve, for your incredible expertise and insights this evening. I've learned an awful lot myself, so I hope that those of you watching have done as well. So a massive thank you for being here and sharing your knowledge with us.
Pleasure.
Thank you.
Thank you very much.
Thank you.
For everybody else, obviously, if you are not already a member of the European movement, please do join us. We are a cross-party campaign campaigning for closer relationships with our European friends and neighbours. We also have a current petition calling on Rishi Sunak not to withdraw us from the ECHR as well, which you can find on our website. So if you haven't already, I know many of you will already have seen that petition, but if you haven't signed it, then please do so. That is on our website. Well, in fact, it is right there on the screen. So yes, a final thank you very much. We will be obviously focusing on a general election campaign over the next 5 to 6 weeks, but webinars of this type will be resuming after the general election period has resumed. So please get on our mailing list to have updates on our activities and things at the European movement up to then. So it leaves me to say just have a nice evening. Thank you very much for joining us, and I hope we'll see you again at our next event. Thank you very much.